good evening to all of you. Welcome to DAKSH's annual Constitution Day lecture. DAKSH is a think tank based in Bangalore. We do work on judicial reforms and access to justice. Our work is deeply grounded in constitutional values, and hence this is an event that is like a flagship event for us. We usually have this lecture in Bangalore, but this year we decided to try out a new city. Big thanks to all of you for coming, taking time out of your busy schedules to come for this event. We're very excited to have Mr. Cyril Shroff, Managing Partner of Cyril Amarchand, Mangaldas, to deliver today's lecture. We are also very privileged to have Justice Gautam Patel as the guest of honor for this event.
Thank you, Leah. I was telling both Mr. Shroff and Justice Patel earlier that I will tell the audience that they need no introduction and then go on to introduce both of them for about 20 minutes. And both of them forbade me from doing that. However, I wanted to just say a few personal things, not about what they have done, because we all know what they have done. We are privileged to have two of the finest minds in the Indian legal system today with us. I'll first start with Justice Patel, who has been a big supporter of DAKSH from the last 5 years. In fact, I remember, I think there was an event in the held by Dasra, I think at the Taj Mahal Hotel about 5 years ago when I first met him. I had not met him before that, and we were talking about the problems of delay in the judicial system. And I came prepared, to talk to a sitting judge who is going to be so protective of the system, and I have to, so I prepared long notes. And he started speaking first, and when he finished, I didn't have anything to say because all my points had already been covered by Justice Patel. And then we had an interesting conversation. But what I really wanted to say today is what a recently retired judge of the Karnataka High Court had messaged me once about Justice Patel. I had sent out a flyer about Marga, which most of you saw in the video. And Justice Patel and Justice Rajiv Shakdar of the Delhi High Court spoke at the inaugural event of Marga. It's a virtual event. And this judge who is now retired, he responded saying, and I'm just reading out, I dug out the WhatsApp because he told me not to speak about his other achievements. And this is I quote from this judge, said, "This man, Justice Patel, has a rare gift with words. He is interesting, unique in his style, with sharp, crisp sentences, rarely found among Indian judges or lawyers." And I think I couldn't have found like one sentence that just describes Justice Patel. And one of the first orders that I read from Justice Patel was an order that most lawyers would have missed. It was about how the Companies Act 2013 was implemented. And I don't know whether he remembers, I quoted the judgment, entire judgment in my book on the rule of law, about does it just because a ministry announces that certain sections have been implemented doesn't make the sections implemented. It has to be actually published in a gazette. It's a very short judgment, I think of about 10 to 15 pages, but it reveals in its full glory the vacuum in our rule of law system. Something I'm hoping will come out in today's lecture in different facets. So we're grateful that Justice Patel accepted our request to chair today's session. We were convinced in DAKSH that if we were going to hold an event in Bombay for the first time, then we needed to have Justice Patel with us. And we thank you very much, sir, for joining us today. Mr. Shroff, I have known for a lot longer. I first interned with him when I was a student in 1996. It's a very short internship of 15 days, so I don't think I left much of an impression on him, but he left a lot of impact on my thinking about how corporates work in India. And over the years, because many of my friends have been in the organizations that he has led, I've known him better. I think, again, I won't talk much about who he is and what he is, but I think, again, I want to just say one sentence that he set the benchmark for professional legal practice in India. And I think we don't appreciate this much because before 1990s, the legal profession was a very disorganized lot in India. And the advent of the organized corporate legal practice has brought about some semblance of organization. And the benchmark has always been the organizations that Mr. Shroff has led. Earlier, the unified Amarchand, Mangaldas, and Cyril Shroff, and now CAM. And it's what other legal practices in India measure themselves up against. So when I first reached out to him asking whether he would be willing to deliver this lecture and explained what this lecture was all about, he responded very quickly and said, I really want to do this. And then we discussed and agreed upon this topic. So just to explain why we started this lecture series, this is the 11th lecture in this Constitution Day series. While you saw the video about what DAKSH are doing, we also felt that we needed one event every year where we reflect on what the Constitution means to us in our daily lives, beyond the headlines, beyond the 1% sensationalism that hijacks the message of the Constitution in many senses. So we envisaged the lecture as an event where serious practitioners and academics would look at problems that they work on, analyze what has happened over the last 70 to 75 years, and then pose questions as to how, pose questions for the future and how we should move forward. Because the Constitution, as we know, is an evolving document. So that was the purpose of the of organizing this lecture. We've been lucky to have, over the years, many good speakers deliver the lecture. Over the last 3 years, it was virtual in format. And this is the first time that we have come out of Bangalore and out of the virtual format. And when we thought about law, business, and the Constitution, we knew that we had to ask Mr. Shroff to deliver this lecture. So thank you, sir, for accepting a lecture. And I now request Mr. Shroff to kindly come and deliver the lecture. Also request Justice Patel to join us on the...
Respected Justice Gautam Patel, our guest of honor, several friends and dignitaries in the audience, members of the DAKSH organization, thank you for having me today. And I really enjoyed that video because I didn't know every detail of it, but must say it was very, very impressive. And Harish, ever since you invited me in early August 22 to deliver this lecture, I have been most excited. And apart from the honor of delivering this talk, I have immensely enjoyed immersing myself as a student of the law in the preparation. So with the Harvey Specter, the idea of a corporate lawyer discussing the Constitution may seem a contradiction in terms. You expect Atticus Finch from To Kill a Mockingbird or Clarence Darrow rather than a Harvey Specter or Louis Litt, both of whom I resemble in different ways, to discuss the Constitution. Now, as the crow flies, the distance between court number 1 on Tilak Marg in Delhi and my office in Lower Parel is substantial. However, almost daily, the reverberations arising from the Constitutional Court's gavel affect us corporate lawyers in the country's commercial and financial capital significantly, and of course our clients. One may ask what the lofty principles of constitutional and administrative law have to do with the kinetic energy of corporate law involving mergers and acquisitions, capital markets, high finance, financial markets, regulation, insolvency and bankruptcy, and so on. Symbolically, the Bombay Boardroom is primarily concerned with value creation for all stakeholders, efficiency, innovation, shareholder rights, corporate governance, and the ESG obligations. The Constitution and the Supreme Court of India have a seminal role to play qua these factors, in addition to ensuring the certainty and consistency of our commercial laws. It is also interesting that some of the deepest issues on constitutional law and the most hard-fought constitutional principles have evolved in the context of issues of economic rights and liberties. The basic structure doctrine and the right to property is the most easily recognized illustration of this. There are others I will come to. India Inc. is a key stakeholder in our constitutional evolution. The state of administrative law and the rule of law in general as well. It is the same judges that evolve groundbreaking jurisprudence on individual rights and administrative law who also pronounce judgments on the most pressing commercial questions of the day. As to locus on enforceability of corporations' rights, it is well settled that corporations may not themselves directly avail of protections bestowed in Part 3 of the Constitution. Petitions may nonetheless be maintainable if shareholder rights are infringed. Therefore, indirectly, the interests of the company do receive the benefits of constitutional scrutiny. Constitutional challenges extend far beyond Part 3 of property rights. Even the controversial agricultural laws had a business side to it. The high courts are also constitutional courts, and often Article 226 is the remedy for business seeking relief from state excesses. And after much evolution, the courts have been able to draw a line in the sand between the realms of public law and private law. The case of LIC versus Escorts is seminal in this behalf. And again, this was in the mainstream of an epic corporate battle. The evolution of constitutional law and the business and corporate law are far more intertwined than it appears at first blush. As we celebrate 75 years of India's independence, or Azadi Ka Amrit Mahotsav as it's called, and are close to completing 73 years as a republic, it is only appropriate that this Constitution Day, the view from the Bombay Boardroom, be added to the collective discourse on our founding document. This is especially as the next 25 years, the Amrit Kal, will come to define India's legacy in the world. Now, India's future tryst with destiny. As an economy, we took 58 years to get to our first $1 trillion of GDP, 12 years to get to the next trillion, and 5 years to the third trillion. It is anticipated that within the next decade, we will start adding $1 trillion to its GDP every 12 to 18 months, putting us well on track to be a $30 trillion economy by 2050. And it is expected that by 2050, 20% of the global GDP will come from India, like in olden times. Given this dramatic surge in national economic might and influence globally, our Constitution, as interpreted by the judiciary, will play a defining role in making India an economic superpower that is predicated on the rule of law and in ensuring our diversity and democracy. Our journey to such global eminence is founded on our concepts of nationhood, and it has no parallel in global history. Let me now take stock of our apex court in present times. There is much to be proud of. It is imperative to reiterate that the apex court's present period is certainly one of the great dynamism and progressiveness. Examples abound, both administrative and substantive. The rapid and comprehensive adoption of technology during the pandemic and its continued use has not only created efficiency, but also access to justice. The commitment to clearing arrears has been impacted not only by using technology, but also by innovative listing methods. And undoubtedly, the record appointments made by the recent Chief Justices to fill long-standing vacancies is going to contribute. Chief Justice of India D.Y. Chandrachud's recent comments on improving the infrastructure, both hard and soft, of the district judiciary is also welcome. A conference is being held tomorrow on Constitution Day, which will be attended by the Prime Minister and all key stakeholders of the Indian judiciary. Now, a track record and global appreciation. On the substantive side, our jurisprudence, both in terms of public and private law, has progressed at a good canter. Our landmark cases are noted and appreciated across the globe. As I travel internationally, a number of my lawyer friends talk about it. The apex court's decisions have importantly advanced the rights of minorities and the marginalized by securing women a permanent commission in the army, by providing clarity to Hindu women's rights in succession, by decriminalizing homosexuality, putting in abeyance the law of sedition, and most importantly and recently, by developing the right to privacy under the umbrella of Article 21. Recent progress? The recently released draft Personal Data Protection Bill has sprung forth somewhat belatedly from the Apex Court's 9-1 decision in 2017. On the side of business and the economy, most recently the Apex Court has been very forward-looking in its evolution of the law of insolvency as well as arbitration. Retired Justice Rohinton Nariman specially deserves a mention in this for his seminal contributions. But it's not always a bed of roses. While the above praise is certainly merited, it may not entirely be, as I said, a bed of roses. Procedurally, the perennial mounting of arrears, and we saw that in the video a few moments ago, and the tariq pe tariq culture poses the greatest challenge of the average citizens, to the average citizen's faith in the legal system and to our global reputation on enforcement of contracts. Substantially, the court also continues to face challenges in ensuring certainty and consistency in its holdings. Recent rulings regarding the insolvency code have deviated from the established principles of supremacy of commercial wisdom, of the committee of creditors, established waterfall of dues with the states being subordinated, and the requirement of the NCLT to admit a petition when a financial debt exists without exercising any measure of discretion. Inconsistencies have also arisen in the environmental realm regarding the grant of ex post facto clearances, where the court has allowed industries without environmental clearances from obtaining one after commencement of operation. While these are examples of the Apex Court, recent examples, the Apex Court must be mindful of the unintended ramifications of its rulings on the commercial world. The court is indeed final, not because it is right, but is right because it is final. And as a justice of the Supreme Court said recently, finality is good, but justice is better. Now, boardrooms. Now, boardrooms prioritize certainty of laws. And this is something which one must be careful of. The Supreme Court must be wary of some PILs that tend to have a huge impact on the economy. Judicial activism is a good thing, and PILs are a great innovation, but its impact could sometimes be akin to a nuclear explosion. Corporate boardrooms rank the certainty of the law as the highest in their thinking. Boardrooms believe that all risks can be priced except the risk of the unknown unknowns. Foreign investors somewhat cynically look at the Indian judicial risk arising from PILs as an unknown unknown which cannot be priced. The seismic economic effects of the court's blanket rulings on the cancellation of 122 telecom licenses and the coal mines are still being felt. This is despite the fact that telecom has become the cornerstone of the new economy and the basis of the fourth industrial revolution. Such rulings and their after effects should continue to serve as a reminder when possibly well-intentioned public-spirited individuals come knocking on its doors, purporting to advance petitions for the public good. Judges and the Supreme Court must thoroughly unbundle the issues of merit based in the PIL from the private interest that may sometimes be behind them, and in effect weaponize important legal issues. I then talk of institutional augmentation, because for these very reasons, this raises the question of institutional augmentation for the Supreme Court. There should be a feedback mechanism for assessing the repercussions of court's judgments on the economy in certain cases, an impact assessment mechanism. The Supreme Court has recently itself raised this issue of the court assessing the impact of their judgments, but this is a point I will come back to at length later. Let's look at the sweep of history, and I put it in a bit of a filmy context of Kal, Aaj aur Kal. So having taken stock of our Apex Court in the present day, we return to the understanding that the multifarious roles that our apex court and the interpretations of the Constitution have played in our journey so far. It was a daunting task for me, even though I had 3 months to prepare, to summarize 75 plus a future 25 years of jurisprudence in just one lecture. So I divided it into 3 periods. Let us start at the time of India's founding and then move forward. Kal, Aaj or Kal. So for the sake of convenience, the first Kal comprises the period from 1947 to 1991. Aaj comprises the period from 1991 to 2022, present day. And the second Kal is futuristic and covers the Amrit Kal from 2022 to 2047, up till India at 100. So I'll talk about the first Kal, from 1947 to 1991. And in one sentence, if I were to summarize it, it is about the state at the commanding heights. So contrary to belief in some quarters, the Constitution is neither an elite project nor a Western implant. The Constituent Assembly debates indicate that the founders of the Constitution actually had a very clear-eyed view of the Indian realities and created an ingenious and indigenous constitution suited specifically for India's exceptional needs. It is one of the best constitutions in the world. Work by legal historians reveals that the Indians across regions and walks of life adopted the Constitution wholeheartedly, holding the state to account and embracing the rights granted to them, which comprise personal liberty, right to life, and the role of the state in ensuring these rights. But what about economic liberty, economic justice, and the role of the state in the economy? There is much analysis that our founding fathers envisaged for the state. And many of the primary sources, which include the Constituent Assembly debates themselves, have aided the development of jurisprudence about the role of the state, be it the right to property, role of the state in business, qua nationalization, privatization, taxation, or even federalism, and the role of the center and state on legislating upon matters of commerce. There is a strong interconnection between our constitutional values and economic purpose, whether it is employment, wealth distribution, food safety, defense, healthcare, and every need of the citizen has an economic and business angle to it. Even the state has a high dependence on the economy and relies on the private sector. It was the private sector that delivered the COVID vaccine in record time, and which is why we are here today. So the choices before our founding fathers. Whilst our founding fathers and members of the Constituent Assembly were ardent believers in the fruits of the democratic system and the republic constitutions the world over, they were also deeply bruised by the extractive experience of colonial enterprise and the crushing poverty that surrounded them. In 1947, India's average life expectancy was 32 years, and its literacy level was only 12%. These numbers pale in comparison to the present. Access to basic amenities such as food and healthcare were scarce. In 1943, approximately 3 million Indians died due to the Bengal famine. This backdrop certainly had a deep impact upon the thought processes of the leaders of the day in their search for ideas to build the new republic. And one strand of thought that certainly influenced policy in the early days was that of Fabian socialism. Sidney and Beatrice Webb, founders of the Fabian Society, believed that the central wrong of the capitalist system is neither the poverty of the poor nor the riches of the rich. It is the power that mere ownership of the instruments of production gives to a relatively small section of the community over the actions of their fellow citizens. So the state at the commanding heights and the transformative role that they played. Granville Austin, the first biographer of the Constitution, argued that the members of the Constituent Assembly were driven by a need to achieve social revolution through the Constitution. Arvind Alangovan, in his work on B.N. Rao, the constitutional advisor to the Assembly, further states that for Austin, the decisions by the members of the Assembly to incorporate universal adult franchise, including a set of fundamental rights and directive principles, enshrine mechanisms to balance the power between various branches of the state, as well as between the center and the provinces. So what happened was, from subjects, whether it is of the kings or whether it was of the British Empire, we became citizens. And a more recent academic perspective is from the scholar Madhav Khosla, who in his work, it's a lovely book, India's Founding Moment, he provides the following rationale for a strong center and for putting the state at the commanding heights of the economy. Khosla states that the existence of a centralized state involved a turn to modernity, including the power dimension associated with modern institutions, and enabled a new kind of intersubjectivity. And India's founders saw localism as burdened by a set of practice that disabled an individual. Simply put, natives were seen without a politics that could enable self-rule. The founders sought to liberate India from localism and to rescue them from villages and kings in order to grant them collective agency. Look at the irony of history. Churchill, at the time prior to India's freedom, had commented that if independence is granted to India, power will go to the hands of rascals, rogues, freebooters. I quote, "All Indian leaders will be of low caliber and men of straw. They will fight among themselves for power, and India will be lost in political squabbles." Is it not ironic that as India celebrates 75 years, Rishi Sunak, a man of Indian origin, has now taken the reins at Downing Street? And this is also the year where we overtook UK as an economy in the GDP terms. And it is an interesting inversion of colonialism and the East India Company syndrome, that we are now the second largest contributors to UK's FDI and an important trading partner. So as we look at the reality then, what were some of the initial contestations? As we have understood the economic realities, intellectual basis and subsequent analysis, what were some of the big fights? The first big fight was Nehru versus the zamindars. As the high idealism of the days of the framing of the founding text lapsed and legislative realities came to confront the leaders of the day, new forms of contestation arose within the framework. And the first, as originally drafted, the first constitution originally drafted provided for the right to property as a fundamental right. However, our first government, having beaten the drum of land reforms, whilst we were still a subject people, were keen to carry out drastic land reforms and redistribute property in order to further social justice. Given that the right to property inhered, this quickly led to tension between the government and the judiciary over the extent to which legislature had the power to engage in such redistribution of property rights. This was a clear contradiction, and the battle lines of the first big battle were drawn. Nehru, in his autobiography, wrote that democracy and capitalism grew up together in the 19th century, but they were not mutually compatible. There was a basic contradiction between them, for democracy laid stress on the power of the many, whilst capitalism gave real power to only a few. Uniquely, the leaders of the day, however, did not perceive any embracing conflict between the democratic political ideals and the socialist economic ones, which were otherwise inherently contradictory. Other socialist systems which have evolved in other places in the world were quite the opposite. Equally, our leaders did not see a contradiction between the socialist ideals and the inclusion of the right of property as a fundamental right. In practice, as we will see, as the ink had not even dried on 26 January 1950, that our individual economic liberties were challenged for the state's socialist ideals. So the first such mega battle took place between the zamindars and the government machinery that was preparing for zamindari abolition, the most important element of the Congress Party's initial socio-economic agenda. I won't, in the interest of time, I won't go into the whole history, but there was the famous case of the Maharaja of Darbhanga, Kameshwar Singh, and the judgment of the Patna High Court, which effectively held that the amendment, the legislation was unconstitutional, which caused panic in the government of the day, and then came about when Nehru introduced the first constitutional amendment bill. The bill sought to circumscribe the right to property and validate zamindari abolition by adding 2 new articles, 31A and 31B, empowering the state to acquire estates without paying equitable compensation and ensuring that any law prohibiting such acquisition would not be deemed to void even if it abridged the bill. This is the famous 9th schedule. In the introduction of the bill, Nehru remarked, and apologies to all of us, that somehow we found that the magnificent constitution that we had framed had been kidnapped and purloined by lawyers. On the other hand, the opponents of the amendment, such as S.P. Mukherjee, called it the beginning of the encroachment of the liberty of the people of free India, given that laws could be made immune from challenges by putting them in some schedule. And it took 50 years in the Coelho case, which was held that even if you're in the 9th schedule, you still had to meet the basic structure test, thanks to the Keshav Nanda Bharti case. Now I talk about the foundations of substantive due process, which was another major theme that evolved. So the major fault lines that emerged in this period arose from the impact that the state's policies adopted had on individual economic liberty. Following the contentions that arose qua the right to property, and as Indira Gandhi started to stamp her dominance on the Indian politics, an entirely new set of contests and battlefields arose between the executive and the judiciary. Many of the court's judgments during this period that adorn the history of our Supreme Court relate to rights of citizens being upheld against an overbearing state. In addition to the path-breaking line of cases leading to Keshav Nanda Bharti, the 11-judge bench in the bank nationalization case, R.C. Cooper, also acquitted, the Supreme Court acquitted itself quite admirably. But the most important next development was in the case of Maneka Gandhi versus Union of India, which read into Article 21, substantive due process. Article 21 reads, "No person shall be deprived of his life or liberty except in accordance to a procedure established by law." So in the position prior to Maneka Gandhi's case, it would not have mattered whether or not that law itself was unreasonable and arbitrary. However, with the development of the theory of intersubjectivity of rights, the golden trinity of Article 14, 19, and 21 ensured that now the court would have to go a step further and test whether or not the law on the basis of which an individual was affected by state policy was itself just, fair, and reasonable. And this laid a basis, a major basis, for a check on arbitrary state action and served as a tremendous fillip to the development of administrative law and the application to economic statutes. I call it the new age of administrative law. Moving on, how did the judiciary begin to shackle the Indian Leviathan, which is what I also call the sunrise of Article 14? As the seminal principles began to take shape in our court's jurisprudence, this major contestation developed most vividly within the framework of commodity controls. The various orders issued under this system of controls criminalized the offenses of hoarding, dealing on black market, tax evasion, food adulteration, etc. The main protagonists here were small merchants or the Baniya Marwadis. Apologies to any Marwadis, including my wife. And the Controls Commissioner. So in this area, particularly in the 60s and 90s, the merchant popularly became the economic criminal. Popular culture personified this criminal in Bollywood movies as the greedy and exploitative Baniya, moneylender, hoarder. I think there was an actor called Jeevan who used to personify that role. It was in this era that the common person too lived at the largest of the state machinery. And in the popular culture, one may see Amitabh Bachchan, the angry young man in films such as Janjeer, as a product of these times. So the court faced a constant barrage of petitions from merchants to control and define the often excessively delegated powers which the Controls Commissioner enjoyed and often abused. The Yale legal historian Rohit Dey, in his work, A People's Constitution, the everyday life in the law of the Indian Republic, uses the examples of the Baglas, the Marwadi traders, and the legal challenge against the cotton textile order as part of a system of controls to show how, with the coming of the Constitution, merchants and traders could hold the government to account for abuse of excessive discretionary power. Therefore, while the green shoots of controlling arbitrary state behavior did emerge in this period prior to Manmohan Singh's 1991 reforms, the sheer weight of the laws, regulations, and orders made in purported public interest weighed down individuals' economic cycle. And another academic, Shruti Rajgopalan, summarizes it beautifully in what she calls the 5-step cycle. She believes that the constitutional and socialist projects of this era were totally incompatible. And she illustrates this mismatch according to this 5-step cycle, which in her opinion repeated itself 25 times. First, the Planning Commission led by the Prime Minister creates 5-year plans for the economy. Second, these 5-year plans get converted to central or state legislation. Third, the legislation is challenged in courts and subject to independent judicial review. Fourth, one such legislation is struck down as unconstitutional for violating fundamental rights. To give validity to such void or unconstitutional legislation, Parliament amends the Constitution. So this circle of life goes on, and it apparently went on 25 times. And to buttress, therefore, she says that this is exactly how the Constitution evolved during this period. So this brings me to an end of the first cull from 47 in terms of the major strokes to 1991. Let me move now to the Aaj, about a 30-year period from 1991 to 2022. And I caption it as where the court is the handmaiden to economic progress. The monumental economic reforms of 91 are often seen as a reactive move made in a moment of crisis and submission to the prevailing Washington consensus. The reality is certainly more complex. And whilst the crisis served as an immediate trigger that pushed the political class of, if it ain't broke, don't fix it, the reforms themselves were a culmination of deliberations through the 80s. Manmohan Singh stated in his 1992 budget that the reforms were an idea. Many of you may remember this speech. Is an idea whose time had come. And this had been coming for a few decades. Nothing could stop it. It was not the currency crisis of 91. And whilst delivering the Nehru Memorial Lecture at Cambridge in the year 1997, Manmohan Singh says, a concerted, multifaceted effort to reform the system had to wait until 1991, even though the shortcomings of the old development model were visible much earlier. The long delay in introducing reforms, even when the case for them was so strong, was largely due to the fact that several important groups had come to acquire a strong vested interest in the perpetuation of the command and control system. Now we move to what I call the diminishing points of friction. So as India's economy opened up and the state slowly embarked upon the process of receding from the all-pervasive role, naturally the Constitution also ceased to a large extent to be a site of contestation between the state and the individual on economic matters. This was possible to a large extent as the systems had become sites of disputes such as those of industrial licensing and price controls. They themselves were dismantled, so to give way to a more market-based setup. So the contestations and battlefields shrunk. But the court still continued to intervene on matters of substantive due process and the rule of law. In this phase, by and large, the courts adopted the policy of economic deference to the executive. The judiciary upheld laws beneficial to the economy and business, be it upholding the constitutionality of statutory bodies, tribunals, fending off constitutional challenges to provisions for which were pro-business, legislation such as the amendment to the Arbitration Act, insolvency, etc. The court developed groundbreaking jurisdiction, having all-round impact by reading into the Constitution the right to privacy as a part of Article 21. This was profound. So in this period, there have been, now this is interesting, in this period there have been more than 25 constitutional amendments, but not a single one of them has been to sidestep an apex court judgment, striking down a government policy as unconstitutional, by contrast with the first phase. The lone exception to this was about executive interference that stands out, and it's not a constitutional issue, was the 2012 retrospective tax amendment that circumvented the Supreme Court judgment in the Vodafone case. So this period of constitutional and judicial evolution was dramatically different from the first cull. Now, on the court's deference to economic policy, so in this era, the government decided to divest and dilute itself from a number of businesses it controlled, as well as state monopolies, and numerous challenges arose with the reform process. Pre-liberalization, the state often privileged its socialist commitments vis-a-vis individual rights. And now the court faced the question of whether or not to interfere in such policy moves undertaken by the government. In the landmark case of Swiss Ribbons versus Union of India, which is the landmark case on insolvency, the court summarized the entire gamut of law from the early 20th century cases of the US Supreme Court to the development by our Supreme Court, and succinctly puts in paragraph 21, quoting the R.K. Garg judgment. Another rule, and I'm quoting here, another rule of equal importance is that laws relating to economic activities should be viewed with greater latitude than laws touching civil rights, such as freedom of speech, religion, etc. The court should feel more inclined to give judicial deference to legislative judgment in the field of economic regulation than in other areas where fundamental human rights are involved. You see the change? The Apex Court reiterated this position earlier this year in the case of Akshay Patel versus RBI, whilst upholding the constitutional validity of the RBI's action regulating the export of PPEs. Now let me talk of judicial difference, not deference, difference qua RBI. The court struck down two of RBI's regulations in 2019 and 20, and in both instances recognizing the Reserve Bank's power to issue the regulation question, but questioning whether due process and the procedure under the parent statute had been followed. These essentially, I will skim through it, it was essentially the February 12th circular on insolvency where banks were directed, and the other was on cryptocurrency. This was a major move by the Supreme Court into the realm of otherwise what was a no-go land. And it is perhaps this trend that emboldened the private bank to challenge RBI's policy on ownership. This matter was settled, but a new front has certainly opened up, and the RBI realized that times are a-changin'. Let me talk about tribunalization and the impetus to ADR. Tribunalization is a major theme of our times. And to help address the persistent delays and backlog that accumulated in time-sensitive cases, the Supreme Court upheld the competence to set up tribunals as alternatives to courts. In the Madras Bar Association case, Supreme Court upheld the constitution of NCLT and NCLAT to be valid. Now, in my view, whilst the journey of tribunalization across subject areas has been long, the numerous constitutional challenges, the real problem is the vacancies that exist in a variety of tribunals, which tend to defeat the very purpose of their creation, which is to reduce the workload of the high courts. For the NCLT alone, as of July 22, there were 30 vacancies for members and almost 270 vacancies for staff. The number of cases pending stood at 21,000. And whilst the onus of appointment is on the executive, it is important for the two organs to work together. The jury is still out on whether tribunalization has been successful or has merely created an optical illusion of easing the court's backlog. Tribunals essentially have the same pathology, but without the due process safeguards. It's not the same thing. Now on arbitration. On the arbitration front, the Supreme Court deserves stellar marks. With the principle of party autonomy and a largely hands-off approach becoming the order of the day, the judiciary has provided a massive fillip to the arbitration regime. Recently the newly introduced Section 87 of the Arbitration Act was struck down in the Hindustan construction case on account of it being manifestly arbitrary, in that it stipulated that the changes brought about by the 2015 amendment could only be applicable post that. Such an approach by the Supreme Court serves to create a pro-arbitration and pro-business environment. Now, whilst arbitration is resorted to mitigate the delays and uncertainties of the court process, it is a moot point as to whether arbitration resolves the primary need of evolving the law. It is an open question as to whether arbitral process has adequate impact on the development of jurisprudence or furthering of the law. Now, to sum up, in the AJ period, the Indian economy has gone from strength to strength, lifting hundreds of millions of people out of poverty, developing world-class infrastructure, and consistently being at the head of a club of large economies with a high growth rate. And as it is evident from the aforesaid analysis, the apex court, barring a few aberrations, has undoubtedly complemented the executive in India's larger economic journey, the handmaiden. I recollect a conversation I had with Justice Gautam Patel over a decade ago in a legal conference. I wonder whether he'll remember it, at the International Bar Association in Mumbai, when we both reflected on the proposition as to whether courts were resolvers of disputes and protectors of rights, but are they not also a part of the team that implemented economic policy? Is not the judiciary also a part of the economic team of the nation? I will not tell you what we concluded, but I know we had a very lengthy discussion on this. So this brings me to the end of the AJ period. And now we go to my favorite part, which is the second Kal. So as we enter Amrit Kal and Liberalization 2.0, many a parliamentary legislation and executive action will be tested on constitutional grounds. With the rise of the power of the state on the one hand, but contradicting also the shrinking of the state through actions like privatization and asset monetization on the other hand, the dominance of big tech and its attendant risk, climate risk, and the need for new responses, I believe that the Supreme Court, on the judiciary in general, will have to pivot several times to meet new situations arising out of such developments. Let me talk about the bossy state. In January 2022, The Economist magazine ran a cover story, many of you may have read it, called "Welcome to the Era of the Bossy State." It examined the evolving relationships between governments and business. It concludes that a new and most turbulent phase is underway as citizens are demanding action ranging from social justice to climate change. The state has moved from being merely an owner, like in the nationalization time, or an umpire during the middle phase, to a backseat driver. America is pursuing soft protectionism, and in China, Xi Jinping is leading the common prosperity crackdown to curb the excesses of the free-wheeling board. Do you even hear about Jack Ma anymore? It's a new polity. In most democracies, the lure of state intervention is bipartisan. Nobody wants to fight elections based on open borders or free markets. Governments are redesigning global capitalism, and the interventionist mindset is converging around policies that fall short of nationalization, but it's a very nuanced approach around sectors where the state regards strategic matters. FDI rules globally are bent to suit the geopolitics of the day. CFIUS in America, Press Note 3 in India are examples. The stakes are high. The state and the business, faced by conflicting aims, will fail to make the best trade-offs. And instead of intervening to make the markets better, what will actually emerge is a new style of, this is what the article concludes, a bossy government. Rather poignantly, the article concludes, whilst its adherents will hope for prosperity, fairness, and security, they are more likely to end up with inefficiency, vested interests, and insularity. And I believe a lot of this will play out in India as well. And in Amrit Kal, we will see the next generation 70 constitutional litigation and mega contests. Hitherto, the weight of case law has been heavily focused on the relationship, and again, I know this phrase was used, of Samaj, Sarkar, and Bazaar. So the law has been heavily focused on the contest between Samaj and Sarkar. But looking ahead, I can see that the bazaar will also get involved, thereby doing full justice to the trinity of Samaj, Sarkar and Bazaar as the foundation of a progressive society. In the next 25 years, we will transform from a developing to a developed economy, from a weaker nation to an economic and military superpower, from a poor nation to a rich nation. We need a world-class legal system to match this transformation. So whilst I can think of many issues, here are the 10 big issues that will arise as the major contestations in the next 25 years. Issue number 1, antitrust competition. With the increasing concentration of economic power and control of data by large corporations, new monopolies will have to be dealt by the court, and the old orthodoxies of antitrust law are already being thrown in the dustbin in many markets in the world. Issue number 2, corporate law and the emergence of jurisprudence around purpose and stakeholder governance. Our Companies Act of 2013 is pioneering in terms of imposing on companies a duty towards maximizing value not just to shareholders but to stakeholders, including employees, the environment and the community. Will our Supreme Court chalk out the purpose of a corporation in view of the new ESG regime and further the decision in its own judgment in the case of the Great Indian Bustard, which became the first ruling to expand and explain the scope of directors' duties? Will other stakeholders be given class action rights similar to the rights that shareholders have under Section 245? I believe we are one judicial innovation away from this. Issue number 3, privatization. The coming wave of privatization and asset monetization will raise new questions regarding the tensions between value maximization and process sanctity. Further questions may reach the court with regard to the processing of unbundling of property rights in asset monetization. In asset monetization, the asset is not transferred. It's only given out on a concession basis for 30 or 50 years. So there will be new contestations on where does the value exist and what safeguards for public interest will need to be provided for. I expect the Supreme Court is going to test this very carefully. Issue number 4, climate litigation. With the increasing salience of climate change, and once courts are able to establish a system of attribution to the causation and is able to identify individuals and corporations behind climate change, questions as to their extraterritoriality and liability with the public interest will be raised. There is already a case that has been filed in Latin America against polluters in Europe, suing them in an international court for the damage that they caused to the global environment, which had an impact in Latin America. I can see more of this happening. And India has been one of the greatest polluters historically. So let's see where that goes. Issue number 5, expanding the boundaries of public law. Whilst at present Part 3 rights, fundamental rights, are only enforceable against the state and its instrumentalities, which satisfy the public function test, with large corporations arrogating to themselves the rights of a state and are becoming quasi-sovereign, will private law actions by private corporations be held to constitutional standards under public law? Question. Issue number 6, the metaverse. In the event that the metaverse does indeed come about, will the laws of the physical world extend into the metaverse? What will be the constitutional basis to assume jurisdiction? Will our constitution even apply in the metaverse? Whose constitution will apply? So that deserves a thought. Issue number 7, privacy. It is fundamentally a right that citizens have against the state. And although this is a new dimension between individual and corporations, the new draft data protection bill, which is a nice simple piece of legislation, a lot has been put down into delegated legislation and rules, and a lot of responsibility on data fiduciaries. The questions regarding the role of the state will be raised before the apex court and will be a topic of great contest. Issue number 8, ethics. What would be the legal and ethical foundation of artificial intelligence and the new boundaries of biology? How will constitutional law provide a framework for creating a new social contract in these difficult spaces? What will Article 21 have to say about some of this? Issue number 9, litigation finance. Will the apex court clear the issue or clear the air on the issue of third-party financing and open the floodgates of class action suits in India? And issue number 10, it's probably one of the most important ones, is balancing the state and private enterprise. Now, India's promise of Amrit Kal is not going to be achieved because of what the state is going to do. The private sector will be a huge contributory to the future prosperity. Now, how will the state create an environment of trust and entrepreneurship? Will there be freedom to fail without being considered a criminal? How will the bossy state control its worst instincts? And who is going to control these instincts? So these, I believe, are some of the 10 issues that face us. And for many of the younger ones, you will see this play out in your lifetime and careers. Alexander Hamilton, in Federalist Paper number 78, says that the judiciary has no influence either over the sword or the purse, no direction of the strength or the wealth of society, and can take no active resolution whatever. It may be truly be said to have neither force nor will, but merely judgment. Given that it is only judgment, what is required, and it was brought out very nicely in the video, DAKSH video, it requires public confidence to maintain an equilibrium between the executive and the legislature. So as I come to the end of my lecture, I again put on my hat as a corporate lawyer, the view from the Bombay Boardroom, and as a futurist. Because I hate to leave unaddressed problem statements. So I do not profess to have any magical solutions nor any exceptional wisdom, but in my opinion, we need 3 major ideas to develop if we are to embrace our second tryst with destiny for 2047. And whilst I'll elaborate each one of them, here are the 3. First, judicial accountability based on impact assessment. Second, modernizing the court processes to 21st century standards. And the third, getting the bar and the legal profession future ready. So this is no ordinary ride ahead of us. So idea number 1, judicial accountability based on impact assessment. The court is the final arbiter of the Constitution, and its impact on economic issues is all-pervasive. In addition to judicial deference, the judiciary should also conduct judicial impact assessment on its own judgments, both ex ante and ex post, to be aware of and take into account. And where possible, resolve the economic impact of judgments that the court delivers. This exercise is particularly important when it comes to matters of economic importance and which are more often than not brought by way of PILs. The Supreme Court is fully alive to this issue, and in the recent Shiv Shakti Sugar's judgment states, and I'm quoting only one sentence from it, in a situation where 2 views are possible or where there is discretion given to the court by law, the court needs to lean in favor of the particular view which subserves the economic interests of the nation. The court states that its rule, in addition to viewing the matter before it from instead of just looking at the issue before it, it needs to view it from a constitutional lens. And the court went on further to say that where 2 competing interpretations are possible, it must take the view that is in the economic interest of the nation. This is ex ante. But what about ex post? Ex post as well, the court should regularly undertake such impact assessment of judgments. And I don't know what the tool for this is, but an independent judicial accountability office which is staffed with economists, lawyers, statisticians, representatives of the government and civil society is an idea to think about. Niti Aayog earlier this year released a report which actually addressed this issue and analyzed the economic impact of certain decisions. And whilst we find it problematic that the executive is involved in such an exercise, the report's finding highlighted the impact of just 5 judgments. The report, which was co-authored by CUTS, which is an organization, claimed that about 25,000 crores and 83,000 jobs were lost just due to 5 cases which the Supreme Court and the NGT delivered, because of the way that the impact that it had on completely halting economic activity on whatever grounds that they dealt with, and had this huge impact. Now, such a study certainly helps towards sensitizing judges as to the economic impact of their decision, and such reports continue to keep the judiciary vigilant, keeping in mind the principle of independence of the judiciary. I think the judiciary should consider establishing such an office within itself. Not for a moment am I suggesting that we should encroach on its independence. I only suggest that the judiciary should hold a mirror to itself from time to time. The Supreme Court, in the judgment of Salem Advocates Associate, Justice Jagannatha Rao, also dealt with a similar issue and submitted to the government that there is a need to have a judicial impact assessment on legislation, and particularly before important cases that come to them. Now, as of now, there is no consensus around this, but is it not time, as we look for 25 years ahead and the journey to 2047, that this issue needs to be considered? The judiciary is seen as the last bastion of justice, and the trust, while it remains high, it has eroded in some respect for the reasons we saw in that video. This is a global conversation. The judiciary is an unelected institution, and across the world there are noises about this very unelected nature that precludes courts sometimes from taking far-reaching decisions. In the US, this is decision. UK has a post-Brexit conversation because the courts decided on the Brexit case as well. Eastern Europe and parts of Asia and Latin America. This is a global conversation, and if the Indian courts are to remain insulated from such criticism, it is imperative that it undertakes actions on its own to preserve its own accountability as well as reputation. A judicial impact office is a powerful tool for the court to achieve this, and if the court undertook it on its own, it would burnish its own legitimacy in golden letters. Idea number 2, reimagining non-core court processes. We've heard this many times. Justice delayed is justice denied. We need a breakthrough idea. We've been talking about it for 30, 40 years. It is essential to not only minimize the judicial bandwidth on administrative matters, but to open up all non-core functions to innovative, non-sovereign or private players to deploy technology to make court management far more efficient. I believe that science and technology can solve anything. Look at how rapidly we evolved the COVID vaccine. What is judicial delay compared to the COVID vaccine? Nothing. We need to open our doors to the private sector and cutting-edge technology, whilst carefully preserving the core of the sovereign judicial function. Let me give another example on the passport, privatization of the passport Seva Kendra. I have friends in America who have to wait 3 to 4 months before they even get a passport appointment. And we're talking of the United States of America. Here, after privatization, when it was given over to a private company, you get your passport in 3 days with an SMS which tells you every half an hour where your file has moved. And that has not taken away the sovereign function of the nation to issue the passport. It is still the government of India which issues the passport. But all the administrative processes have been privatized. Is there a lesson here and a model to be replicated on court processes? And this is not the first time this idea is being mooted. There are a number of court service organizations across the world which have come up with similar systems. In the UK from 2011 onwards, there exists the autonomous, His Majesty's Courts and Tribunal Services. Also in Canada, there's a court administration service established in 2022, which provides a gamut of services for litigants and judges. So you keep only the core sovereign function of the administration of justice to the judges. Everything else should be privatized. Not only is this a great way of creating efficiency, but you also make a lot of money as a state, because you will have private capital flooding in. And you could create infrastructure using just like in the PPP model, the UPI in India, or Aadhaar, or now ONDC. These are all examples where public digital infrastructure or public infrastructure has been created through the PPP model, and there is absolutely nothing wrong with it. So with cutting-edge technology as the cornerstone of these new institutions, the problem of arrears, I believe, can be dramatically reduced. This is a topic for DAKSH to take forward. And I think, as I said, the state can make money in the process because private institutional capital would love to support this cause. Properly done, there will be little or no scope. The first thought will come to be private sector, somebody will manipulate it. I think it's the exact opposite, because if everything is digital and everything has a digital footprint, what is there to manipulate? Everything will be, there will be a track record of everything. Now, India has the biggest problem of arrears in the world, and the greatest impetus to innovate should be naturally, if necessity is the mother of invention, we have the greatest necessity, so we should innovate. And India can lead the innovation in the world on access to justice. And it is the private litigant who has the greatest stake in such process along these lines. Issue number 3, the last one. Idea number 3, which is disrupting the bar and getting the legal profession future ready. I didn't say it, but Justice Chandrachud said it a week ago, where he scathingly opined that the legal profession is akin to an old boys club where opportunities are given only to a selected group in a network. He went on to state that this network opportunities are gotten in senior advocates' chambers through these informal ways. It is not based on merit, and that all this must change, and the burden to change is on all seniors and judges. Given the above comments made by the Chief Justice last week, there is an urgent need to not only modernize, but to institutionalize and make meritocratic the system of apprenticeship and pupillage that exists today. In order for us to find the next Harvey Specter or even the next Mike Ross to appear on the horizon, there is an urgent need for us to decide the path forward to what is our future system of advocacy. The pre-colonial system has become the status quo and continues to persist even whilst Britain has modernized the system several times over since 1947. I should not be complaining about this because law firms like us have been the greatest beneficiaries of the fact that the bar is closed. For a young advocate or a young student passing out of campus, unless you have some connection, the bar is shut. And it is only people like me who give employment and opportunities to the advocacy bar. But that's not necessarily a good thing. I think this requires change. There is a glaring need to improve access and opportunities. Okay, this is the second point, because an old boys club, now let me play on the word boy. There is a glaring need to improve access and opportunities in the profession for women. The diversity statistics in the advocacy bar are abysmal. Some of the barriers for women are not only attitudinal, but plainly prehistoric, given the times that we live in. For example, certain district courts do not even have proper toilets for women. Now, this automatically restricts access. It is important that these issues are addressed to improve the state of our profession today. And the tryst with India at 100 is not possible unless changes are made on all fronts. I must add, with much humility, that these suggestions are from a place of deep respect and affection for our court. There is no Indian who is more proud of India than me. And these suggestions are aimed at the brilliance, at preserving the brilliance and independence of the court and nothing else. In conclusion, I think these are questions which are now upon us, and it is only a matter of time. To end on a positive note, I must say that I have immense faith and hope in the dynamic institution to march forward with these innovations. With the appointment of Justice D.Y. Chandrachud, who is a jewel of the Bombay Bar, as the Chief Justice of the Apex Court, we have all the more reason to be hopeful and assured, given his prescient, progressive, and futuristic judicial temperament, who will keep his deep understanding of the commercial and philosophical requirements of the day in front of him as he discharges the rest of his term. Thank you.
I think we'll all take probably a few days to digest some of the ideas that came out in that lecture. We will have a question-answer session, but before that, I'll request Justice Patel to say a few words.
Good evening. Let's not forget the date. Tomorrow's Constitution Day. This is a Constitution Day lecture. 72 years on. And it is time, I think, that we turn around and ask questions. Hard questions. About what we imagined ourselves to be 72 years ago. What we thought we should be. Whether we have become what we set out to become. And if we haven't, are we going to do anything about it? And if so, what? Don't be misled today by the quietness in the room or the quietness of Cyril. He's one of the most effacing people I know. If he could be invisible and do his work, he'd do that. We are a noisy lot, Indians, always have been. And in this cacophony, because we're so busy engaging with this or that seemingly important thing of the moment, we forget to have, as often as we should, essential conversations. Cyril begins with a hint and then leaves it. But I want to touch on this for just half a minute. And he says, what does constitutional law have to do with commerce? I want to upend this question a bit and ask, what does the Constitution have to do with commerce or with business? My answer is everything. We have become so used to seeing the Constitution as being limited to certain parts of Part 3 fundamental rights, that we're not really seeing the Constitution for what it is, which is a charter for us as a society in all its forms, including the way we go about living, working, earning, and yes, doing business. There are phrases in the Constitution that are important, and we've begun to fling a couple of them about without really pausing to think about them. One of those words is justice. The Constitution begins with this. And we have to pause once in a while to ask what this means and what it really means. Cyril touched upon this, and I think that's an important point in the progression of history. When we began, we were perhaps reacting to 2.5 centuries of gross exploitation. He mentioned the Bengal famine. There's enough documentation to show that that was, at least in some ways, engineered at a horrendous cost to human life. And the result was that we wound up with what is now clearly a false binary of capitalism versus socialism, as if this is a question that will ever receive an intelligible answer, or rich versus poor, which is another question, because there have been rich always and there have been poor always. The only question really that we need to ask ourselves is about efficiency. What is the most efficient, the most economical way to do the most equity, to do the greatest good? The labels that you attach to this don't matter. A principle of governance that says we will take it away because we think you have too much does not address the question of either justice or of efficiency. Certainty is the other aspect that Cyril touched upon. He mentioned this in the context of commercial enterprises, business, yes, obviously. And the obvious examples, again, are taxation. You must know where you stand and what the tax law is. But there's a more fundamental thing at play here. Certainty in decision-making. There can't be consistency, there will be changes, but certainty has two components to it. One is predictability. For a person like Cyril, one of the worst things, worst nightmares, to have is when asked by a client what will happen in a given scenario, is to be forced to a position where he has to say, we don't know, let's see what the courts do. That has a devastating downstream effect because corporates and businesses, and they're not necessarily by definition rapacious, do not know how to plan. Certainty is required because it is the fundamental underpinning of the rule of law. People know what to do and how to go about doing it if the law is certain. Ambiguities and uncertainties in the law create a disorderly, a disruptive, a disorganized society whose progress towards greater equity is always impeded. Commercial entities, okay, let me give you this example from today. It's quite an interesting statistic. My list today, this Friday, was entirely of writ petitions, claims for protection under Article 226, invoking some form or some right under Part 3 of the Constitution, arbitrariness or a violation of an Article 19 right, one of the freedoms. I just quickly looked at that list on the phone and I counted. 47% of the cases totally today were by commercial entities, not individuals. 47%. There were some coming in for pension, for individual benefits, but a full 47% of the others were in court invoking a constitutional right in the context of a commercial enterprise. Now that should tell you somewhat, or give you some idea of where we are going with this conversation. The other aspect that everyone talks about is pendency, and I do want to engage with DAKSH on this. I've mentioned it to Surya once before, perhaps in passing, but it's a larger conversation. Nobody has defined it. Nobody knows what this beast is, and it is the 800-pound gorilla in the room. Let me straight away give you one thought, and then I'll leave you with that. The minute a case of any description is filed, it is pending. It immediately, your meter, your ticker goes up by one. But that case is not ready for disposal by the fastest of the fastest of the fastest judges. It can't be done. Because the judicial process mandates that you have to give a copy of this lawsuit, find the other side, serve him, get him to court, give him time to respond to your case. Once he has filed it, and fair enough, don't give him endless adjournments, I accept that. Once he's been given enough opportunity, then decide it. How is it pending until then? These numbers lie. And they have to be sorted out, and unless you sort out and identify the problems, you're never going to be able to address the solution correctly. You're looking at this huge mountain, and you're wondering how you'll ever get over it. So late evening yesterday, conversation with one of my fellow judges as we were walking back, or walking out, I forget which. And he says, you know, it's an odd thing. What will we say about ourselves at the end of our tenure as judges once we've retired? That there was this ocean of cases, and after 10 or 12 or 15 years, maybe I emptied 2 buckets out of it. But the ocean is what it is, and glaciers melt faster than we can dispose of cases. Why? How? Many solutions, many problems, but it is crucial to an advancement of the system. On the bossy state and on privatization, 2 thoughts. How much privatization and of what would we as the people accept as being constitutionally valid? How many of our resources would you accept passing into private hands? Control of water, drinking water, breathable air. What are the limits to this privatization? And there must be some limits, we must define those. On the bossy state, I did read the article in The Economist. I think actually it missed the point, at least from our context. Look carefully. The government is now a market player. It wants to be a corporate. And it is a jealous and envious market player, and one armed ferociously with powers that private corporates do not have. This is going to be a test of the future. We are going to have to test how much corporate impulse from the government can be accepted as constitutionally good. We are going to have to redefine the boundaries of what a government can legitimately and permissibly do in the name of governance. How far exactly can it go? This is a direct collision with the other thought that Cyril gave us of privatization, because the two don't go hand in hand. At some point, this is going to be an almost cataclysmic explosion, and it's going to happen in the law courts with very, very far-reaching consequences. The last point that I want to leave you with, which is why I told Cyril I need a copy of this paper, is what is it that judges should be doing in court? Should we just, on Alexander Hamilton, should we just give you a judgment and then just leave it to you to figure out what you want to do with it? Or should we issue and continue issuing directions and demanding compliance? Are we crossing lines, crossing boundaries, going over into the other side of organs of government? I don't know. Society has to decide this for us and has to tell us that if you as judges are going to function, then you only deliver judgment on what the law says and how things stand. What to do with your judgment, we will decide, not you. It's possibly one philosophical view, but that will also shape the future. There's one more issue that's going to come in addition to the others that Cyril mentioned. Of course, environment and climate change is going to be a problem, and it's going to be essentially a measuring problem. Let me just give you, in a minute, explain this. Everyone will say that, oh, you know, that piece of land, it should be preserved as a forest. And you should not have an industry near there, or you should not have a highway through it. Nobody is measuring relative costs in a scientific, acceptable manner. This is something that we have to start doing, because it's not a contest between rupees on one side and what is nice to have on the other. That's a false metric, and that is an untenable position going forward. The other issue that's going to happen in corporates and in boardrooms are struggles, tussles, contestations as companies become bigger and bigger and become huge buccaneering behemoths, very much like the East India Company used to be, and that conflict with minority rights. This is going to be a big thing because you have now extremely empowered minority rights. And as corporates get bigger, their management tends to get more cautious. They've got a whole lot more to lose, whereas the minorities seem to want them to be more aggressive and adventurous in corporate decision-making. Now, this is going to be a conflict, and old settled law is going to be upended, I think, in the next 5 or 10 years when we are looking at minority rights and so on. The paper that Cyril read has, I think, food for thought for a long time. There are, apart from the historical perspective, and some of that was extremely interesting, there are individual items that we have to address, and I do hope that with Daksh's assistance, at least those that pertain directly to the judiciary, we will be able to address in the time ahead. Thank you all for being here. Thank you very much.
We'll take some questions from the audience. So can I request you to keep the question brief and be direct to the point so we can get reactions from both Cyril and Justice Patel.
Thank you for that extremely enlightening lecture. My name is Nilesh Hundekari. I'm a management consultant, not a lawyer. Mr. Shroff, your second point about efficiency in the processes is something that I have personally believed in, even though I'm very much an outside person in this case. But I did want to understand, it seems like the right thing to do. What are some of the challenges that have actually prevented us from doing it? As you rightly gave the example of you've done it in the passport case. What are really the challenges that have actually prevented in making that happen?
To some extent, I'm guessing here. But a part of it is a kind of a status quoist attitude of, this is the way it's working, why do we need to change it? And even though the arrears problem keeps piling up, there is a deep suspicion that if you take some aspect of a sovereign function, and especially something as important as dispensation of justice, and involve the private sector in this, that you are setting yourself up for manipulation, criticism, lot of public debate around this, which is not necessarily sort of encouraging as well. Because I have actually raised this idea with the government a couple of times, and I've just been met with a stone wall as well. So it's an idea whose time has come, but it requires political courage to do this. And we need not even try it in the superior judiciary. Let's try it on consumer court. Let's try it on a tribunal. Let's try it somewhere. Because passport was the same principle. By involving a private sector company, have you taken away the right of the sovereign to decide who to issue the passport or not? You haven't. It still continues to be intact. All that you've done is add a heavy dose of efficiency, and it has made all the difference. And there are several examples of this, of how you could create public infrastructure. And we are living in the 21st century. So I think it is a combination of inertia, fear of the political unknown, and there's no political will as yet. No, it's a private citizen who's involved in efficiency. Nobody.
There are actually two fears here, Nilesh. Let me tell you. This is from a judiciary perspective, but it will apply to almost anything. Courts and court systems, judiciaries that manage them, are extremely apprehensive about allowing outsiders access to any part of their systems, papers, records, whatever it is. One fear is theft, damage, some of historical records. Security is often raised as an answer. I don't pretend to understand this fully. a pending case, I can understand, should not go around, but there are ways to do this. But there's also a fear of why should somebody be making money or profit out of doing this? Because this is, after all, justice dispensation. It's just inefficient. In the Bombay High Court, because we are a court of record, we have records going back 150 years. That's a monumental amount of physical paper, and we've run out of space. Now, we can't be a high court and also do warehousing. There are more efficient ways to do this. We should not actually be reinventing the wheel and trying to do in-house digitization when it can efficiently be outsourced even to a commercial enterprise like others do. Court after court will tell you, we must have our data servers and our server farms, and we must have them on our campus. Why? It doesn't matter what cloud your data in. All right, you may want it in India, but if it's over Roorkee or somewhere in Madhya Pradesh, that's good enough. You don't actually have to reinvent the wheel. AWS hosts any amount of this stuff. Why are we reinventing it? We have to break through on this. And I want to add to this, with Justice Chandrachud today also heading the E-Committee, we really hope that we're going to be able to accelerate some of these projects which have been under discussion for a period of time and get them rolling.
So I want to add one more comment, and I think the philosophical root of this problem is that as of now, the kind of conventional wisdom of the day is that justice is a place. Nyay chahiye to court jao. Whereas actually the modern concept is that justice is a service. If we were to make this transition from moving away from justice being a place where you have to go, which brings in with the same problem of that the data has to be stored in the premises and in the basement and all of that, and move it away to it is a service which is to be delivered to the citizen, then you can start thinking about the service in the form of efficiencies and how it is that you can create the most important efficiency. Until we make that psychological change about starting to see that this is the state providing a service and it should use all the means at its commands, including the private sector where it is required, subject to all the safeguards that were mentioned, that is when this will happen. Until then, it's not going to happen.
Thank you very much.
And stop calling them temples.
You're right. You can still call them temples.
Don't call them lords, don't call them temples. Just call them courts.
Hi, sorry. So I'm Avanti. My question sort of is about, as you were saying, right, like using technology to augment justice delivery. What are your thoughts, I mean, this is kind of radical, on using AI for adjudication, right? So there are courts in the US and other jurisdictions that use it for certain types of cases, like bail applications or something. How would you see this in the future?
It's being worked on. DAKSH is in partnership with other agencies that are working on precisely these models, identification, segregation, prediction, and so on and so forth, that's going on. But the talk of AI tends to be larger than it actually can deliver. So you have to see this in the context of what is possible and what is not. And if you're saying that, will a computer decide a case, well, good luck to you with that. Yeah. That's the distinction between artificial intelligence and natural stupidity.
No, I think there's a big issue, and I think I mentioned it as one of the 10 issues on the ethics of artificial intelligence, because inherently he who writes the algorithm for that artificial will have a bias, and you will perpetuate that bias in the outcome. So I would be a little careful, even though I'm a great believer in technology. Yeah, for data mining backwards, yes, but for giving, or even for predicting outcomes, there is a lot that is going on. But for actually delivering the outcome, it has to be a human being.
Okay, if while people are considering whether to... Ajay?
Hi, I'm Ajay Kumar. My question has to do with accountability in the judiciary. In recent times, we've had 2 cases of Chief Justices where a lot of questions were raised about who they are finally accountable to. As Mr. Shroff mentioned in his lecture, the judiciary holds the other branches of government to account. But over the years, with judicial decisions in India, we've now reached a position where it's very difficult for the other branches to hold the judiciary to account. I'd like to ask both the panelists, what is this? How does this impact?
No, I'll leave. I'm not answering.
All right, sorry, sir. How does this actually impact there being rule of law if you can't hold those who enforce the law to account, especially in India, where the average human being is more affected by a judicial decision than, say, in any other jurisdiction? Tomorrow, this court could actually literally ban things like an e-cigarette or tell me that I can't have tinted windows in my car. So it's affecting me in my daily life, what's going on in Tilak Marg, and I can't hold anyone accountable as a voter, as a citizen.
Yeah, I mean, this is a deeper question, but I think I already answered that in some form in the lecture. Firstly, I don't think we should compromise the principle of independence of the judiciary in any manner, because at the moment you do that, I think the whole structure of separation of powers and all of that starts coming apart. So let's keep that off bounds. That being said, as far as accountability is concerned, I mean, the idea that I left was that at least on certain types of cases, the judiciary must itself hold a mirror to itself and hold itself accountable. Because any other form, if the executive is going to make the judiciary accountable, you run into the independence problem. So, as I was also thinking about it, I don't think any other idea makes full sense except either you have created an ombudsman type of structure, which has independent people, but that also a lot depends on the kind of people you find in it, and so it's very human dependent. But if the judiciary itself were to say, I'm holding a mirror to myself on certain types of cases, at least cases which have an economic impact arising out of PIL, even if we take that narrow sliver, which has the most impact, I think that is at least something which can have a big impact, because the ramifications of some of the cases are so large. I think we took 10 years to come out of a recession because of certain cases. So therefore, I would confine it just now to a narrow sliver. More broadly, who will judge the judges is a different question for another day. And if it involves infringing the independence of the judiciary, I would not go in that territory. I think that's going too far. I love the independence of the judiciary, and this is what makes India India. That's why we are not China. And I think that I would not trade off that freedom or that faith in the system for anything else. Not for efficiency, certainly.
Actually, let me tell you, that's a rolled up question. I'll tell you why. What is your question about accountability? Is it about the judges or is it about the judgments? If it's about the judgments, time, history, progress of society will judge the judgments, either find them wanting, get them reversed, get them altered. If you want to hold judges accountable, you have to be clear what you're holding them accountable for. Lateness, picking up some cases, not picking up some cases. When you define the question more accurately, we'll answer it.
Good evening, sir. I have a question. My name is Krishna Wakhure. I am from GLC, LLB, third year. Sir, what are the opportunities available for visually impaired person advocate in technology? I think Sharafat sir, he spoke about e-technology. So what are the opportunities available there, and which type of software you are provide to us? So will you please answer?
So I don't know the technical answer, but we used to have a lawyer called Amarchand. He was for many years in our capital markets practice, and we had provided all the infrastructure that he needed. But then for personal reasons, he had to move to Delhi. So we've been through that route. If you ask me the name of the software, I don't know, but the software does exist. Okay. We, as a firm, we have a sort of a DEI agenda. And we do have people who have different types of disabilities, and we do support them. It's a small number, but in principle, we have accepted that idea, and we made it a core value of our firm.
I'm told, I think so since I have the mic, I'm going to ask one last question to Cyril mainly. You talked about certainty. You started off by talking about certainty and what the boardroom looks at. And then you talked about uncertainty that judgments can cause, and the likely areas of dispute and contestation in the coming years. Justice Patel also referred to that, the same thing. So, uncertainty is not our hallmark. That, I mean, if we can say one thing about the Indian legal system, I think uncertainty is the name of the game, not certainty. So how do you see this developing, particularly as the areas of contestations are new and different from what we have seen, and the capacities both in Parliament and in the judiciary to deal with these new areas of contestations are at the moment in question? I mean, Parliament is the first arena where these contestations happen. How do you see this certainty developing? And is this something that could harm us when you talk about Bazaar and Samaj and Sarkar?
So I must first kind of set the ground with that. My response on that certainty was I was staying close to the topic of a view from the boardroom. And who are the stakeholders in the boardroom? There are the shareholders. There are those who kind of represent different other stakeholders as well, including foreign investors. And for them, it's an economic assessment and an economic relationship. In that economic relationship, what they're looking for is certainty, because it can be priced, they can assess the strength or weaknesses of their rights and plot their further course of action. It's very difficult if the answer to everything is, we don't know, it all depends. And I think Justice Patel also gave, he illustrated my worst nightmare, which I think all of us from law firms face every day, is when we are asked by our clients to say what will happen over here, and we say it all depends. And I think that certainly enhances the risks and the uncertainty from the client's point of view. And how do they deal with it? What they deal with it is they assume the worst case, price it accordingly, and effectively deduct it. So that can't be the right, it cannot be the most efficient sort of outcome. So whether we'll be able to eliminate all uncertainty? No. Can we mitigate it? Yes. How do we mitigate it? I think firstly we have to prevent zigzags from happening. So the law on a lot of important things, including particularly taxation, has gone through so many zigzags. It's like a snakes and ladders game. You know, sometimes you sort of go up and then suddenly there's a snake and you come all the way down again, and it's all back to, it's a kind of a vicious circle of life that goes on. And the tax lawyers face the worst of it. But even otherwise, in terms of different other branches of commercial law, the uncertainty is our worst nightmare. That is why you have 50 qualifications in the opinion, one of which actually used to be, we don't know. That's the reality. And this level of uncertainty is probably highest in our country just now. When, for example, one of the reasons why we always, in a way, lose the argument on choice of Indian law versus English law is the counterparty will say, English law I can predict to the last the last full stop in the judgment. Whereas Indian law, you guys are great, very intellectual, very philosophical, 2000 years of history and all of that, but can you please tell me what's going to happen here? And the answer is, we don't know. That's where, bolte na wahan maar kha jate hain, unnecessarily, because we actually have a great legal system, some of the brightest minds in the world. It's a relatively small problem to fix, but if we are going to be always the argumentative Indian who's going to argue on each and everything, then there's a problem.
That was a very thought-provoking and engaging Q&A session. We are nearly at the end of today's proceedings. I'd like to invite my colleagues Surya and Harshita to present tokens of appreciation to our guests, Mr. Cyril Shroff and Justice Patel.
I also want to thank my team that has helped me on this, and then particularly Richa, who's not here, and Yash, who's sitting there somewhere. Yash, please stand up. There was a lot of help on research which was required. Thank you.
I now call upon Surya to deliver the vote of thanks.
There's really not much you can add after such an enriching session. The great minds, you asked them a question. they give you an answer which is so enriched with experience and a vastness of perspective. We were, honestly, I was expecting something on constitutional law, and the discussion went into institutional aspects, capacity and society. Fascinating to watch how the conversation and the camaraderie and the complementarity between Justice Patel and Cyril Shroff. Thank you so much, both of you, sir, for enriching all of us with this. Thank you, audience, for making it to this event, the Nehru Center for allowing us, and the media who has covered us. Looking forward to many more such conversations and having you as part of DAKSH. So the dependency is being done as part of the Judicial Data Collaborative, right on top of the list, sir. We should have some updates soon. Thank you, all of you. Thank you.